Welcome to a deep dive, everyone, where we're going to be taking a look at a pretty big Supreme Court case.
Yeah, big one.
That looks at the immunity of international organizations.
That's right.
So kind of a wonky topic, but really important one.
Oh, absolutely. And one that, we've all kind of heard about, but maybe don't quite understand all the intricacies of.
Right.
So today we're going to unpack the Jambi International Finance Corporation case.
Okay.
And this is a case that, really grapples with this fundamental question.
Yeah.
Does the IOIA, the International Organizations Immunities Act, grant international organizations the same kind of evolving immunity that foreign governments get under the FSIA?
Right.
The Foreign Sovereign Immunities Act as it exists today.
Right.
Or is it a kind of fixed thing, based on the common law understanding way back in 1945 when the IOIA was passed?
Right. So it's like, do these organizations get the same kind of legal protection that a country would get? And does that protection change as laws change?
Yeah, that's exactly right.
Okay, so to get us started,
yeah,
what did the Supreme Court actually decide in this case?
Well, the court sided with the petitioners, Buddhist Ismail Jam and others, basically concluding that the IOIA, it does actually grant these international organizations that same immunity that foreign governments have under the FSIA, today.
Okay.
So that means that immunity, it's not frozen in time. It actually evolves as the FSIA itself changes.
Got it. So as the rules change for how we treat foreign governments, the same rules apply to these international organizations.
Exactly.
Got it. Okay, so let's break down the core arguments here. What were the main points that the people who brought the case, the petitioners, what were they saying?
Right. So their lawyer, Jeffrey L. Fisher, he made a multi-pronged argument.
Yeah.
Really interesting.
Yep.
He started with the text, just focusing on the actual language of the IOIA.
Yeah.
And he zeroed in on the word is, where the law describes, the immunity of foreign governments.
Wow.
And legally speaking, that present tense is typically means at the time of the lawsuit.
Okay, so very specific.
Very specific.
Like a present day interpretation.
Exactly.
Interesting.
So he's saying that Congress, when they wrote this, they meant to tie the immunity of these organizations to whatever the current immunity is for foreign governments, at the time the case is heard.
Right.
And he argued that this reading fits with the structure of the IOIA as a whole, and its legislative history.
Okay, so he's really emphasizing the plain language of the law itself.
Absolutely. And bolstering that with, okay, how does this fit into the broader context of this whole law and how it came about?
Right.
And then he went on to cite a bunch of precedents,
okay.
Cases that support this idea that when one law refers to another body of law and it uses that present tense, it means that law as it stands now.
Got it.
Not as it stood back then.
Okay.
And he directly addressed the counter argument. The other side was saying, well, no, it's means back in 1945. He said that just doesn't hold up under the relevant case law. The one case they cited on that point was an Armed Career Criminal Act case. And there the word is referred to the timing of a prior conviction.
Right.
Not the statute's enactment. So very different context.
Very different situation. So basically, he's saying their example doesn't really apply here.
Doesn't really apply here. Very different situation. Now, going beyond the text, Fisher also argued that Congress totally has the power to grant very specific heightened immunity to international organizations.
Okay.
If they want to. He used the example of the Organization of American States, OAS.
Okay.
They got a special deal, a higher level of immunity through a separate agreement. So his point is, if an organization truly needs that extra protection, there are ways to get it. It's not automatically baked into the IOIA.
Right. So you don't need to assume it's there by default.
Exactly.
If you need it, you can go get it.
You can go get it. And then he also raised this really interesting point about, sticking with that 1945 understanding of immunity. He said that would actually bring back a problem that Congress was trying to solve with the FSIA in the first place.
Oh, interesting. What problem was that?
So before the FSIA, it was basically up to the executive branch, the State Department, to decide about immunity on a case-by-case basis.
Mm-hmm.
And that could be swayed by, political considerations and things like that. Congress wanted to create a more stable, legally defined system.
So it was less about individual judgment calls and more about here are the rules.
Exactly. More about a rule of law approach.
Yeah.
He also invoked the reference canon.
Okay.
That's a rule of statutory interpretation.
Right.
And basically it says when a law refers to another existing law, it usually means that law as it currently stands, especially when it's a dynamic area like sovereign immunity.
Okay, that makes sense. So the law is designed to adapt as the legal landscape changes.
Exactly. And then just to top it off, he pointed out a difference in language within the IOIA itself. Section 288, it uses different wording than Section 288.
Okay.
Which suggests that Congress knew how to freeze a law if they wanted to, and they didn't do that in 288A.
Right. So they're making a very deliberate choice in the language they use.
Absolutely.
Okay, so those are some pretty strong arguments from the petitioners.
Yeah.
Now, what about the United States? They were involved in this case too, right?
They were. They filed a brief as what's called an Amicus curiae.
Right.
Basically, a friend of the court.
Right.
And they actually supported the petitioner side in this.
Interesting. So the government was basically saying, we agree with the people who brought this lawsuit.
Yeah. And their lawyer, Jonathan Ellis, he really focused on the structure of the IOIA.
Right.
He said, look, the act lays out different types of immunity.
Okay.
Some of it's fixed, like protecting archives or giving immunity to officials for their actions in their role.
Right.
But then you've got other sections, like the one at the heart of this case, Section 288AB, and that defines immunity based on whatever the immunity of foreign governments is.
Okay.
And he pointed out that the other side actually conceded that the language in some other sections of the IOIA, 288 and 288E refers to the current law.
Yeah.
So their argument that this one section is somehow stuck in 1945, it just doesn't make sense within the context of the whole act.
Right. It seems like they're trying to have it both ways.
It does seem that way. And then Ellis, he brought up the presidential authority.
Okay.
Under Section 288 of the IOIA. The president actually has the power to limit immunity.
Uh-huh.
And he said that makes more sense if Congress intended for these organizations to start with really broad immunity, maybe even absolute immunity like in 1945.
Right.
Because then the president has that power to scale it back if needed.
Right. So it's kind of a check on that power.
Exactly. And he emphasized this applies to all immunities under the IOIA. So it's not just a one-off thing.
Right. It's kind of built into the system.
Built into the system. Now, he also wanted to reassure the court that even with an evolving standard of immunity, these international organizations, they're still going to have a good amount of protection.
Okay.
They're not going to be suddenly exposed to all kinds of lawsuits.
Right.
He pointed out that commercial activity exception under the FSIA, that wouldn't completely wipe out their immunity.
Okay.
And he even suggested that in this specific case, the lawsuit might be barred because the gravamen of the suit.
And the gravamen, remind me what that is.
Yeah, so the gravamen is the most significant part of the lawsuit, the real core of it. And in this case, the gravamen relates to actions and injuries that happened in India, not the United States.
Right.
So even with evolving immunity, there are still legal principles that can protect these organizations.
Right. So it's not like the floodgates are opening and anybody can sue them for anything?
Exactly. And he also addressed that floodgates concern. He said a lot of international organizations are headquartered here in the U.S., but many of them have their own immunity rules laid out in their charters.
Got it.
And he reminded the court that the U.S. has a history of making specific agreements to grant absolute immunity when it's really needed. He mentioned the OAS again.
Right.
And he also pointed out that the lending activities of these development banks, to governments, with all these conditions attached, that might not even be considered commercial activity under the FSIA.
Interesting. So there's a lot of nuance to how those rules might actually apply in practice.
A lot of nuance. And then this is important. He noted that a lot of these organizations, like the IFC in this case, they already waive immunity for some of their core activities, like financial stuff.
Right.
Because they need to function in the global system.
Right. It would be pretty hard to operate if you couldn't be sued.
Yeah, exactly. And finally, he argued that applying an evolving standard of immunity, it lets U.S. citizens and residents sue these organizations in U.S. courts for actions that take place in the U.S.
Right.
Kind of like they can sue foreign governments. And he felt that this was in line with what Congress intended.
Right. So treating them in a similar way.
Exactly.
Okay. So we've got the petitioners, we've got the U.S. government, both making these really compelling arguments for this dynamic view of immunity.
Yeah.
Now, what about the other side? What was the International Finance Corporation, the IFC? What were they arguing?
Right. So their lawyer, Donald B. Verrilli, Jr., He argued very forcefully for a fixed level of immunity.
Okay.
And he described it as virtually absolute immunity, as it was understood back in 1945. He said the IOIA uses common law terms that had this really settled meaning of pretty much absolute immunity back then, and that Congress meant to keep it that way.
So their argument is like when they said immunity enjoyed by foreign governments in 1945, they meant something very specific and broad, and we should stick with that.
Exactly.
Right.
And he argued that Congress's main goal in passing the IOIA was to fulfill these treaty obligations that committed the U.S. to providing this very high level of immunity. And he said those obligations didn't necessarily require treating international organizations exactly the same as foreign states.
Okay.
The focus was on the standard of immunity that existed back then.
Right.
And he also made the point that if Congress had wanted that immunity to change over time, they would use language similar to the other parts of the IOIA that clearly indicate a dynamic standard.
Right.
And they didn't.
Right. So again, the word choice mattering.
The word choice matters. And he brought up the fact that the president had the power to reduce immunity back then.
Right.
And that this was the standard approach in that era. And he suggested that using normal legal interpretation principles, you'd conclude that Congress intended to give this virtually absolute immunity.
Okay.
And he even referred to the Nader case, which established the principle that when Congress uses terms that had a well-understood legal meaning under the common law, courts should assume that they meant to use that established meaning.
Right.
Unless the law specifically says otherwise, which it doesn't here. But the petitioners, they argued that the common law of sovereign immunity, it wasn't so clearly defined in 1945. They said it was actually in a period of transition. So how did the respondent address that point?
Yeah, how did they respond to that?
So Verrilli, he strongly disagreed with that idea.
Okay.
He said, sure, some folks in the State Department might have been thinking about a shift toward a more restrictive view in 1945, but the Justice Department was still operating under the virtually absolute immunity standard. And that's how the courts understood it, too.
Okay.
He even pointed to that famous 1952 Tate letter, that officially signaled a change in U.S. policy toward restrictive immunity.
Right.
And he noted that the letter didn't actually say the law was unclear in 1945.
Right.
It said the U.S. had been following absolute immunity while other countries were moving toward a more limited view. And that's what prompted the U.S. to change its policy.
Okay, so according to the respondent, it's not like there was this big debate going on back then.
Yeah.
Okay, so Verrilli also talked about the IMF, the WTO, and the OAS, and how they all got these special immunity statutes. The U.S. government had brought those up as examples. How did he address that?
Yeah, so he actually argued that those examples actually support his view. He said they show that the IOIA provided enough immunity initially and that these later statutes were passed for other reasons.
Okay.
Like the IMF statute, that predates the IOIA.
Right.
So it couldn't have been because the IOIA wasn't enough. And he argued that the WTO treaty committed the U.S. to a wider range of immunities under a different UN convention. And then the OAS, they negotiated for absolute immunity, even though the IOIA already existed.
Okay, so he's saying these later specific grants of immunity, they weren't about fixing a problem with the IOIA.
Exactly. They were about specific situations or international agreements.
Got it.
He also emphasized the historical context, after World War II.
Right.
Setting up the UN and the Bretton Woods institutions.
Right.
The goal was to provide really strong immunity to these organizations so they could operate without fear of legal interference.
Right. They needed that stability.
Exactly. And he said treating international organizations just like foreign states under the evolving FSIA, that would be anachronistic, given the different historical context and how sovereign immunity law has developed.
Right. So basically taking a modern concept and trying to impose it backwards.
Right. And he also pointed to Section 288 of the IOIA, which deals with reciprocity.
Okay.
And he said, look, that section actually treats international organizations and foreign states differently in some situations. Even if the U.S. wouldn't give full immunity to a foreign state because it wasn't getting the same treatment in return, an international organization would still get that full immunity.
Okay.
And he argued that this shows there's a fixed level of immunity for these organizations.
Okay. Independent of what happens with foreign states.
Exactly. So he also brought up some practical concerns.
Okay.
These organizations, they're funded by member states.
Right.
And if they're exposed to these huge tort judgments, it could really undermine their missions.
Right. It could drain their resources.
And he also pointed out that the D.C. Circuit, They've always interpreted the IOIA as providing this virtually absolute immunity for decades.
Right.
And there's no evidence that this has caused major problems.
Right. So if it ain't broke, don't fix it kind of thing.
Kinda, yeah. And he said changing that long-standing interpretation could be disruptive and create a lot of uncertainty.
Right. People need to know what the rules are.
Exactly. He also warned that if you apply restrictive immunity, you could see a lot more lawsuits against international organizations,
Right. Yeah.
especially those based in the U.S.
Right.
And it could really hinder their work. He called it foreign cubed litigation,
Okay.
where the organization gets dragged into disputes that really happen somewhere else.
Right.
And he specifically talked about organizations like the IFC
Right.
that lend money in developing countries,
Right.
places that may not have the strongest legal and environmental protections.
Right.
And he said, if you hold them liable in U.S. courts for the actions of their borrowers, it could discourage them from doing business in those places, and
Sure.
promoting better standards.
Right. So it's a disincentive to actually do good work.
Right. Finally, he pointed out that a lot of these organizations have their own internal accountability systems.
Okay.
And lawsuits could undermine those processes.
Right.
And he also noted that they have ways to protect themselves financially
Right.
against potential liabilities.
Okay. So the respondent really came with a lot of arguments.
Yeah, they get.
Rooted in the original intent, their interpretation of the law,
Yeah.
and, practical considerations.
Right.
So how did the petitioners respond to all of that?
Right. So in his rebuttal, Jeffrey Fisher, he stuck to his guns,
Okay.
the text. He said that present tense is, we got to give it its plain meaning.
Right.
And he pushed back on the idea that the common law was totally settled in 1945. But he said even if it wasn't in flux, a general reference to common law in a statute usually means it's dynamic,
Right.
not fixed in time.
Okay.
And he warned that the respondent's interpretation, that could create problems across tons of other federal laws
Right.
that also reference common law principles.
So it's not just about this one case.
Exactly. It could have broader implications. He also disputed the respondent's claims about treaty obligations.
Okay.
He said the agreements at the time of the IOIA, they didn't actually require this virtually absolute immunity. It was more about immunity that was necessary for the organizations to function,
Okay.
which is different.
Right. More nuanced.
More nuanced. And he pointed out that these days, commercial activities are often part of the core functions of these organizations.
Right. It's not like they're just sitting in a room making decisions anymore. They're out in the world doing things.
They're out in the world doing things. And finally, he said, look, these organizations, they have ways to manage liability
Right.
through contracts and stuff.
Okay.
And he said the respondent hadn't fully fleshed out their arguments around the gravamen test, which could still protect them.
Okay. So it's like both sides are really going back and forth on all these different points.
Absolutely.
It's a really, really interesting case.
It is.
So now for our 10th chair segment, right? Where we put on our Supreme Court robes and pretend we're part of the court.
Exactly.
So if you were on the court, how would you have approached this decision? What are the things you'd be weighing?
Well, I think you'd find yourself thinking about that desire for stability, right?
Right.
And the idea that the IOIA was originally meant to protect these new international organizations,
Right.
shield them from lawsuits so they could really get going and do their work.
Right.
But then you'd also have to consider how much these organizations have changed
Yeah.
over the decades. They're much bigger,
Right.
more powerful, more involved in all kinds of activities, especially commercial stuff.
Right.
And that might lead you to think that a more flexible approach to immunity is needed.
Right. Things have changed.
Things have changed. And I think, holding international organizations accountable under the same framework that we use for foreign governments,
Right.
with those exceptions for commercial activity and stuff,
Right.
that seems like a pretty good balance.
Okay.
It respects their important functions,
Right.
but it also gives people a way to seek legal recourse if they're harmed.
Right. Especially if it happens here in the U.S.
Exactly. And the fact that there are still options for specific immunity agreements, that provides extra flexibility and, that concern about a ton of lawsuits. Well,
Right, yes.
the FSIA already has limitations and exceptions
Okay.
that could help manage that.
Right.
So I think ultimately a dynamic approach that acknowledges how both international organizations and sovereign immunity law have evolved, that just seems like the best way to ensure justice and accountability.
Yeah. That's a really, really fascinating perspective. This deep dive into JAM v. International Finance Corporation really highlights just how tricky it is to interpret laws that reference other legal frameworks.
Absolutely.
Especially when you're dealing with stuff that's constantly changing, like sovereign immunity and these international organizations.
It is.
And the Supreme Court's decision here, it has big implications.
It does.
For how these organizations operate in the U.S. and how accountable they are.
Big implications.
So it's really something to think about. What are the arguments? What are the potential consequences of each side winning?
Right.
I think this case opens up a lot of broader questions.
It is.
About what these international organizations are supposed to be doing.
Yeah.
What responsibilities they have.
Yeah.
How do they relate to national legal systems?
It's a big question.
It's a big question. So hopefully this deep dive has given you a better understanding of the key issues at stake in this case.
Yeah.
And we encourage you to keep digging into this stuff.
Absolutely.
Learn more about the FSIA, the IOIA.
Yeah.
Really form your own informed opinion on these issues.
Absolutely.
So thanks for joining us on this deep dive.
It's been great talking about this.
And we'll see you next time.